Hello, my name is Bob Clifford. I am Senior Counsel and founder of Clifford Law Offices in Chicago, Illinois. We are a firm devoted to representing families and individuals in injury and wrongful death cases, oftentimes in commercial aviation litigation. I currently serve as lead counsel for all the families against Boeing for the crash of the 737 MAX 8 aircraft on March 10, 2019 in Addis Ababa. There's a trial currently scheduled for that case here in Chicago on April 7th here in the Federal District Court. But today I speak to you about Casey Crafton and the action that we have taken on behalf of his family, his wife Rachel, and their three lovely little boys. We have filed today with the U.S. government, both for the FAA and the U.S. Army, what's called a Form 95 Notice of Claim. I know you can't see this, but at least you can't read it. But it's a document provided by the government that you fill out, and it must be filed with the agency that's you're complaining of, and it has to be filed in order to eventually initiate litigation against that agency. So in this case, our families will be filing eventually litigation against the FAA for air traffic control, maybe other issues, and also the U.S. Army for the involvement of the three crewmen in the crash with American Eagle PSA Flight 5342. And the nature of the form that we file today is it triggers a timeline, it triggers a clock, because as I say, you cannot file a lawsuit against the government simply by walking across the street. You have to give them notice and you have to ask permission. The government has 6 months in which to accept or reject the claim. In my experience, they always reject the claim or they just don't answer it. And given the nature of what we know about this crash, there is absolutely no reason to not get that clock running because, as a matter of fact, it's a very useful thing to get running given the timeline that the National Transportation Safety Board has promised the families regarding the issuance of a preliminary report of their investigation. We know from everything about that's been revealed to date about the crash that there's also involvement by American Airlines and American Eagle PSA, possibly Sikorsky Aircraft. And therefore, what we did today with them on a simultaneous basis is that we have issued evidence preservation letters to them that requires the corporations to preserve and protect the designated information that they are gathering in connection with their participation in the NTSB's investigation. It also requires them to protect additional information, in this instance, that's associated with what we believe may well be some willful neglect in how the airlines allow their commercial aircraft to operate out of Reagan National. It's been known for some time that there are major congestion problems between the commercial aircraft at that airport and the military aircraft. And yet we know that it's our nation's capital. The military is everywhere. The Pentagon is right there. So it's obviously natural that there will be military aircraft in and around that airport. But it's documented that there's a congestion problem that is well known to the aviation industry, and there's going to be legitimate questions asked about how preventable this crash was in light of that. We know that on the night of the crash, President Trump correctly described this as a preventable disaster. and it's our intention to fully seek information by all of the participants in the cause of this crash. Unfortunately, the families are not allowed, either through a liaison or some representative, to participate in the investigation. That's the nature of federal law regarding investigation of air disasters. There are parties to that investigation that the NTSB designates, and it's always the people that we eventually might be suing. So American Airlines is a party. Sikorsky Aircraft is a party. The Airline Pilots Association and the flight attendants unions are participants. The FAA is a participant, and yet the families are not. They're locked out of it. To its credit, the NTSB has been very good at disclosing information both privately to the families and also to the public about the status of their investigation. And one of the reasons why we did not today issue a lawsuit, actually, to the airlines is that the NTSB has made the unprecedented commitment to release their investigative findings on a preliminary basis within 30 days. We're not sure when they started that clock. It could be on the date of the crash. It could be when they recovered the wreckage. It could be any number of things. But in the interim period, that time is of value to the families. And because of the delay associated with the claim process against the government, we're trying to get this clock running and accelerated, which will help us not only represent our clients on the liability side of the case, but it will give us time to work with the families to gather the information and the proof necessary to present their cases for eventual trial. In that regard, by the way, any claim against the government here will be prosecuted in the United States District Court. It will be in front of a federal judge. The federal judge does not use a jury, although the courts can. The judge can impanel a jury as advisory to the court, but the ultimate decision about any liability or compensation to be awarded the families is exclusively within the province of the district court. Unlike the claims against the airlines and whether or not there's a claim against Sikorsky or any of the avionics manufacturers, such as Collins, those claims are presented to a jury. And frequently these claims are consolidated, but they may not be here. And by the way, this is not a class action. A class action is something where all of the damage claims are basically the same. Here, instead, these cases will be handled on what's called a consolidated basis, meaning the determination of the cause of this disaster is, while it's common to all families, the actual claims of the individual families will be analyzed on an individualized basis. Every family's claim is different. As we already know, the passengers on this plane were from many states, indeed several countries from around the world. And the laws of those states may vary. The law of Illinois is different than the law of Delaware. That's different than the law of Maryland. That's different than the law of Virginia. And those are the kind of issues, those damage claim issues, will be sorted out by the various judges who will be responsible for handling these cases when they are eventually filed. So it's our plan to work with our clients to gather information regarding their individualized claims, while at the same time working with the experts that we have retained who will help us decipher and sift through the eventual disclosures about causation. But eventually, it will get sorted out. If you look at the responsibility for a crash, oftentimes you think about a pie chart or a ball of 100%. And frequently, more than one actor can be responsible for a disaster like this. and those are the kind of determinations that will eventually be made. But then the primary focus, the eventual focus, will be on what is the just way to reconcile and compensate the families for their losses, and the courts will require that the families participate in a process of resolution, either by themselves where they can mediate those cases or go to trial. And we prepare the cases as if we're going to trial, which is why getting this 6-month time frame running helps us, because we can work with our families to gather the information that's necessary to assert the claims going forward. How and why this crash occurred will get sorted out. Whether it's exclusively on the air traffic control side or the operation of the helicopter side, or sadly something to do with the operation of the aircraft that day, or, as we think is a very important thing to analyze, what could be the willful neglect of the airline to allow its aircraft into this space without special training. There was a time, we know, when special training was required to navigate in and out of Reagan National. Is that the same today? And if not, why not? From my experience, airlines try to cut corners on training. That's actually one of the things that led to the eventual disasters associated with the Boeing crashes. They were cutting a corner on training and the cost of training. We don't know if that's at play here, but I suspect it could be. And those are the kind of things we'll analyze during the course of our investigation. And once we are satisfied that we know enough to file the claims against the airline, we will do so. Because I know one thing. I'm not sure, as anyone is, what the exact cause of this crash was, but I know this: those 60 souls who perished in that crash, the preventable crash, they didn't cause it. And their families didn't cause it. And there's loss and grief and sorrow around, even for all 67 surviving families. And we know that. We take it very seriously. But the passenger families on that aircraft demand justice, they demand answers, and they demand accountability. And they're entitled to that, and they're entitled to eventual change. And so their family members didn't die in vain. They are entitled to eventual change in the operations and to make it safer. And that's how aviation litigation is a positive eventually, because it does force change. Sadly, it forces change that should never have been necessary, but for the losses that have occurred here. So thank you very much. Our filings are posted on the Clifford Law website, and we will post further interviews or remarks, statements like this as needed in the future. Thank you.